Good evening, everyone. I'd like to call the City of Menasha Administration Committee meeting to order. Clerk Galia, whoa, there's a blast from the past, so sorry about that. Clerk Kramer, could we have roll, please?
Alderman Nichols.
Here.
Alderman Eisenach. Here. Alderman Sevenick. Here. Alderman Hammond. Here. Alderman Schmidt. Here. Alderman Tom Grady. Alderman Ted Grady. Here. Alderman Rapella. Here. All are present.
Thank you. My mind was stuck a bit in the past because Attorney Captain is the last of the department heads to have seen my children grow up from being, 5 and 3 years old to teenagers now, other than the mayor. So, department heads at City Hall, Alderman Sevenick. That's where my mind was for a second there, so thank you. Our first item of business is the Administration Committee meeting minutes from June 6th, 2022. Is there a motion to approve them? Alderman Rapella?
Thank you very much, the Honorable Alderman Nichols. I will approve the minutes of the Administration Committee of June 6th, 2022.
Second.
We have a motion by Alderman Rapella and a second from Alderman Tom Grady to approve the minutes. Any questions or conversation? Seeing none, we'll take all in favor signify by saying aye.
Aye.
Any opposed, nay. Minutes are approved. We have one action item this evening, and that is Ordinance 1522, an ordinance amending Title 11, Chapter 1, Section 1111 of the Code of Ordinances under Offenses and Nuisances. It is being introduced by Mayor Merkus, and as indicated during public comments earlier this evening, it is regarding harassment, and I'm going to turn it over to Chief Styka to tell us more about what is being proposed.
Thank you, Alderman Nichols. What's in front of you is, in addition to the 1111 section, 1111 incorporates a variety of other state statutes. The benefit of doing this is you don't have to create your own language as a municipality, and then there's some consistency amongst the courts as well as amongst the other jurisdictions. The Village of Fox Crossing, as well as the cities of Appleton and Neenah, do already incorporate State Statute 947.013, which is the harassment statute. The reason to bring this to your attention is there are a number of times that there are cases that we've had in the city that don't rise to the level of a criminal charge. And as we've talked about as a police department for years, is we like to have alternatives to criminal things. If there's a possibility of giving someone a ticket for something instead of having a criminal record for the rest of their lives, we think that's in the better interest of people when they make a mistake. We also know that there's a variety of different issues that exist today that didn't exist in the past, such as like internet-based type of harassment, things on Facebook or text messages or those kinds of things. In the past, we have tried to refer some of those to the district attorney's office, and the district attorney's office refuses to prosecute. And those are extreme cases too. This isn't something that someone says something and neighbor shouts something across the yard and they want to be arrested for harassment. That's not the way the statute works. If you look at it, which there's the hyperlink that was on the computer screen, brings up the state statute. So really what we're looking at is there's 3 sections to the harassment portion under the state statute. One falls under the forfeitures, some falls into the misdemeanors, and some falls into actually a felony charge. Well, if it rises to the level of a misdemeanor or a felony, that's usually a case that the DA's office is going to take on. What we're looking at is the forfeiture, because the district attorney's office does not prosecute forfeitures. You would need to do that on a municipal level, and that's why we're bringing this to your attention. So the 2 sections that fall under forfeitures would be if a person with the intent to harass or intimidate another person does any of the following: strikes, shoves, kicks, or otherwise subjects the person to physical contact or attempts to threaten to do the same. And then the other one is engages in a course of conduct repeatedly commits acts which harass or intimidate the person, which serve no legitimate purpose. So it's not just someone says something type of thing. You have to have a history of it that's going on. like my Facebook example or text messages, I would say we've had cases where it's been literally hundreds of text messages where a person's had to change their phone number because that was the only recourse they had. That to me would fall under harassment, and that's one that we could now issue a ticket for if this would pass, instead of trying to refer to court for a criminal charge, if they would be willing to do that, which again, the district attorney's office generally does not do that for forfeitures under the law. So with that, that's kind of the high level of it, and that's what we're trying to accomplish with it, and I'll certainly try to answer any questions I can.
Are there any questions for Chief Stika? Alderman Rapella? I'm sorry, there you go.
No,
You just turned yourself off.
I wanted to.
Okay. Alderman Sevenick?
My questioning is for the chief. I just have a funny feeling about this that, yeah, it's a state statute already, so if it's a state statute, why do we have to do this at all? That's my first question.
Sure, and the answer to that is the district attorney's office refuses to prosecute unless it gets to a much more significant level, generally under the ones of a misdemeanor or felony.
They're not
And-
going to if you have this anyways.
No, this would then get adjudicated through municipal court through our city attorney.
All right. And my other concern is that, and I know you're gonna absolutely, you and your department are just gonna take this wrong, but, maybe I watch too much YouTube. But, they get into a situation where they really feel like, this guy's right, he knows his Second Amendment rights, he knows his Fourth Amendment rights, and I'm going to use this to get at him somehow. That's a fear of mine that, okay, I may not get you into the courts or something, but I'll get you on a minor thing that doesn't necessarily go as far as disorderly conduct, which I think is abused. And now I have this additional weapon to use, and that scares me. And it's not directed at you or your department or anyone else. It's just, what you see in the community. There's a lot of bad cops, just a lot of bad cops. In Menasha, that's not the case. And I'll let our citizens know that because I know the interview process, and I know a number of them, and I know the level of expertise that they have. But I'm afraid of an open-ended thing like this. I just see it like, I don't know what to get them on, I'm gonna use this. Do you see where I'm coming with on that?
I do, and that's where I have to really go back to the definition. So engages in a course of conduct or repeatedly commits acts which harass or intimidate the person and which serves no legitimate purpose. To what you're saying of a person who's protesting, that's a legitimate purpose. And in fact, under the latter part of this, which I think is where the courts and what the legislature meant by this, is under sub 2 of this, it says this section does not prohibit any person from participating in lawful conduct in labor disputes. So this goes back to obviously picket lines and things like that, so it would not be used for that.
Yep, I read that, it's towards the end. So.
Yeah, so my guess would be is that if an officer, either under this ordinance or under the state law, would try to do that to circumvent either, First Amendment, Fourth Amendment, whichever amendment you're talking about, that would be the concern, that would be found to be invalid because there is a legitimate purpose. Person certainly has a right to express their thoughts or concerns, even if it's against with what a municipality or a police department or a court or whatever feels. So I don't know that it would really be applicable or be able to fall into that, but I certainly see where you're coming from on it.
And the other part is, well, and you've heard this line a lot, well, that's your opinion, you feel that way. And if you're right, you'll be right in court. Well, people don't want to have to go to court, even if they're right, to fight something like this, if you know where I'm going with that. So I just hope that it doesn't become a lax thing over time, that this is just, I think that's why Menasha didn't have it. I think it was the opinion of, I'm not gonna quote somebody that's not here, so. I'm not necessarily against this, it's just that, I wanna be able to share my views about this, because, like I said, maybe I watch too much YouTube.
No, you're exactly right. This actually didn't originate from something that we sat around the table at the police department saying, what do we have in the code? This has actually come from a number of citizens that have been very frustrated that situations they've been encountering in the city, and they have no recourse. And they continue to have various forms of harassment towards them. And the DA's office doesn't touch it, and we don't have any tools to help them either.
Well, now I have a perfect example, because I talked to you earlier, and I didn't know where I could share this, and now I can. Because we won't have a meeting until, what, July 5th?
July 5th on a Tuesday.
And the people of Menasha are fed up with the people lighting illegal fireworks. And the message that was sent to me recently was concern about fires, number one, because of the properties around them, and that they actually found a bottle rocket near Clovis School that nearly committed a fire. And we haven't made a lot of attempts on giving any type of citation or anything to people that are doing this. And I know it's a hard process. You gotta, like Rosita just mentioned to me, you gotta catch them, you gotta prove it, and then all that kind of stuff. But in a way, it's become an issue where disturbing the peace almost, because I can't tell you a number of times where I was sleeping at 2:30 or something, and all of a sudden my whole house shook because someone thought it was funny to light some type of rocket into the air that exploded so loud that it shook my house. So people are frustrated with this. And I get frustrated because now we can't really address something like this until after the 4th of July. So would this help in that at all?
No, because not unless it was like a neighbor dispute or something, that this is where the person was getting back at you. Because while I read you the A and B, the first part is whoever with intent to harass or intimidate the other person. So we would have to make the case and somehow prove or demonstrate that the person's actions were being done to
Okay.
harass or intimidate the other person.
And I'm sure there's probably some of that out there,
Well, there could be, yeah.
but they're certainly intimidating me. So, but anyways, I wanted to be able to somehow address that this evening. This is one place I could have done that. So, all right, thank you.
Alderman Ted Grady.
Thank you, Chair. My question also is for Chief Staka. I know there's, as Alderman Severnick kind of alluded to in some of this, there's a lot of gray here, a lot of judgment. And my concern to you and your staff is how much more work is this going to involve, or is it not? I mean, are we going to be having to hire another police officer someday? Or, I mean, we don't know because this is all new, but I'm just worried about the workload on your
The
staff.
harassment officer, yeah. Next personnel committee meeting. No, not at all. Actually, this won't really be much more because we're dealing with these situations on a regular basis. In fact, this should reduce some of those things because when we get the repeated person calling back time and time and time again, because they just got another text message from the ex and they just got another text message. So by having something to do when the district attorney's office chooses not to be able to do something on it, I actually see it to assist those people in that and hopefully circumvent the problems before it becomes something more severe.
Okay, thank you.
You bet.
And Chief, tell me to be quiet if I'm out of line with my question, but your department in the past has always taken an educate first approach to these things, so, or to a lot of things, and so if a new, if a situation should arise that's fairly new, would your officers take that educational approach first with folks involved and use this as sort of a next step or a third step in addressing issues?
You're exactly right. I can't say that it's always going to be the case, because you can have those outliers, but right now, we kind of have the parent that tells your child, I'm gonna, and the parent has really no intent to follow through on the I'm gonna, you know? And so that now people know, it's very simple, you know, what's gonna happen to me? Well, nothing. Because we don't have this in place, and they know it's not to the level that the district attorney's gonna prosecute it, so I'm gonna what? Nothing. And so we're kind of caught. So to your point, it exactly now goes to the fact that we can have the conversation with the person saying, well, here's what can happen to you. You can get a ticket for X amount if you continue in these actions and behaviors, so please just knock it off and be a good person.
So it's a tool in your toolbox.
Correct. Yep.
Thank you. I'll make a motion to forward to council ordinance 1522, an ordinance amending Title 11, Chapter 1, Section 11-1-1 of the Code of Ordinances under offenses and nuisances, introduced by Mayor Merkes. Is there a second? We have a motion by Alderman Nichols and a second by Alderman Rapella. Any other discussion? Seeing none, we'll take a roll call vote.
Motion carries 8-0.
Thank you. And with that, we'll have a motion to adjourn. Motion by Alderman Ted Grady, seconded by Alderman Tom Grady to adjourn. All in favor signify by saying aye. Aye. We are adjourned.